Hello, everyone, and welcome to this masterclass on understanding legal practice and employment law. We start our practice area masterclass with our learning outcomes. So by the end of the masterclass, you should know how to break into this practice area, know what the work of an employment law solicitor involves, and know the key issues facing the practice area right now. To kick things off, we're going to start with Ellie giving a brief introduction about the topic and introduction from each panelist.
Hi everyone, thanks so much for joining us. I'm going to start by asking each of our panelists to briefly introduce themselves. So I'll just start with the order that's popping up on my screen. So Elizabeth, could you start by introducing yourself?
Hi everyone, my name's Lizzie and I'm an associate in Jones Day's Labour and Employment team based in London. And it's nice to meet you all today.
Lovely, thank you. And Carys?
Hi everyone, my name's Carys. I'm an associate in Lewis Silkin's employment team. While our headquarter is down in London, I'm actually based in our Manchester office.
Fantastic. And finally, Helen.
I'm Helen. I'm a legal director in the employment team at Gateley Legal, and I'm based in our Nottingham office. And the picture behind me is Robin Hood, which should give you a clue.
Amazing, thank you. So just to start off with this masterclass about employment law, I want to kind of start off by, I guess, defining what employment law is. Elizabeth, could you give me a bit of a brief understanding of what an employment law covers and why it's such a critical areas of importance for businesses?
Of course, that's a great question. So in essence, employment law sets the rules that govern the relationship between employers on the one hand and individuals on the other, namely employees and workers. It touches every stage of the employment life cycle from hiring and general day-to-day management to termination, including post-termination employment restrictions. And employment law essentially underpins workforce strategy, compliance, culture, and risk management. It's a really interesting area of law. And generally, I would say it provides the framework for recruiting employees, managing them, reorganizing them, exiting employees and workers. And it includes statutory rights and obligations, terms in a contract, collective bargaining, and it intersects with related regimes like data protection, immigration, health and safety, etc. And in terms of why it's such a critical area, I think firstly, non-compliance with the law can lead to employment tribunal claims, injunctions, which can be very expensive for businesses. On the employee side, it protects fundamental rights such as fair pay, working time, and sets minimum standards for safe and dignified work. And I think yes, that's kind of a summary of why it's critical for businesses and employees. And I think for businesses in particular, it's central to legal compliance and workforce productivity. As I mentioned before, failures can lead to litigation, union disputes, delays to transactions, etc. So, yeah.
Thanks, Elizabeth. That gives such a good overview of how broad it is as a sector. I mean, I guess it's true for so many practice areas, but this one really does affect every single business that, every business needs to consider it, because, not considering it has, important as implications. Helen, obviously it's a broad sector. What are the main kind of employment issues that you typically deal with?
So on a day-to-day basis, I'm typically dealing with, actually, it's most of the aspects of the employment life cycle that Elizabeth mentioned. So everything from onboarding people, recruitment selection, which might engage discrimination issues, might engage data protection issues and advice, drafting contracts of employment, being clear about employment status, which is quite often confused. So yes, you've agreed to pay this person as a contractor and they're going to submit invoices and they're not going to pay income tax through PAYE, but actually that's not appropriate. That person is an employee or at the very least a worker, so advising on the employment rights that would come around about the employment rights and obligations on both sides. and then through what in my team anyway we call sort of typical day-to-day advisory work. So grievances, disciplinaries, we solely focus on advising employers rather than advising the employee. So advising employers on how to manage performance management processes, conduct, capability, and all the way through to exits. So actually, a lot of my work is on high value, quite complex executive exits, where I'm involved with negotiating settlement sums and settlement agreements for people who might also be directors of businesses, shareholders. So I'm working with other teams to effect that exit and move that person on. I also do an awful lot of employment work around mergers and acquisitions, so doing employment due diligence, drafting documents, contributing to sale and purchase agreements or business purchase agreements, advising on things like TUPE, which is some European legislation which we've still got, which protects employees' rights when there's a change in ownership or change in the identity of a business. So most of what I do is on the non-contentious side. Other employment lawyers will maybe focus solely on employment tribunals and defending those, but my day-to-day is typically around contracts and compliance, mergers and acquisitions, and as I say, quite a lot of work around high-value exec exit as well. That's pretty much the bulk of what I do on a day-to-day basis.
Thank you. That's really interesting to hear about. And turning to you now, Carys, could you tell me a bit about how specialist employment law can be? As we've kind of heard from Helen already, obviously there's the contentious side, the non-contentious side, and you might choose which side you end up going down, but then obviously I'm sure there's lots of different specialisms within that. Could you tell me a bit about how broadly practitioners tend to focus? I understand it's quite a broad question, and maybe you could tell me a bit about your specialist areas as well.
Yeah, of course. Employment law has so many specialisms. It's one of the reasons I love working there. It's the variety of work. So as Helen touched upon, she's mainly non-contentious, so that advisory side, that corporate M&A side that can come into employment. But there's an awful lot of specialisms that fall within. So at my firm, we have a specialist investigations team, high court litigation, TUPE work, and then you've got within that even smaller specialisms. So you'll have sectors that focus specifically on financial services, or my firm also offer a smaller team of what we call atypical work. So your apprenticeships, so your agency workers. And so there's a lot of umbrellas that can come under employment law, and you can get as specific and as expert in a small area as you like, or you could stay more broad. So I do an awful lot of contentious tribunal work as well. And one of the things I love about that is you often defend any claim that comes through. So if you're working for a client, you'll often support them on whatever the employee might be bringing to the tribunal. So my specialisms generally are in investigations and high court litigation. I very much, possibly opposite to Helen, love the contentious side of the nature of employment law, but that's one of the reasons it's great, is that there is both elements within the law.
Fantastic, thank you. And I'm also keen to touch on, in this masterclass, I guess, different routes into law. Obviously, everyone joining us today is kind of an aspiring lawyer, whether they're a university student or a postgrad. Carys, what inspired you to move into employment law, and how did your previous experience and work experience, I guess, influence that?
So I did do a law degree, and I did a few vacation schemes during that time. And I will be completely honest, I didn't like the law. So I'd found that the different areas I was going to and the firms I was at just didn't suit me. It was a bit more corporate than I was liking. And I think I was a bit out of my depth, if I'm honest, when I was doing these vacation schemes. So I decided to change route. I worked in charity for a while, and then I moved into the civil service, into policy, and I became a senior policy advisor in constitutional law. If anybody has a weird question about constitutional law, that was my specialism. But then I realised I was still working every day with lawyers. I obviously had a love for the law and I was interested in what it can do, how it can influence the country. And so I looked at different areas, what fit that skill set, because you might not like one area of law, but there's so many different ones that involve so many different elements of how you work that I really liked working with people. I really liked that day-to-day interaction with clients and individual. I liked something with a lot of variety, so you don't necessarily know what's going to happen every day or what matter's going to come to you. So I then retrained. So I did a part-time LPC while I was working full-time. I noticed here that there's a lot of people working, so I admire anybody who is studying while working at the same time. I know it can be tough. And then I started my training contract a few years ago and moved into employment law. It was my first seat, so anybody who rules out first or fourth seats, I advise against it. I did employment law and then compared everything else to it because I loved it straight away. So I now work, as mentioned, in various settings within employment law, and I now have specialised into this area.
Great, thanks so much. It's always really interesting to hear about people who take, I guess, when I say alternative routes, I guess the route alternative to just doing a vacation scheme, a training contract, and becoming a trainee straight away, because such a high proportion of lawyers don't do that. They have different work experience before kind of going down that legal specialism, and that can be really beneficial in some cases like this one to sort of, I guess, hone those skills. Turning to you now, Helen. How has your experience coming from a HR background informed your career as a lawyer?
Yeah, so very much like Carys, I did do a law degree. Really loved employment law, which I studied in my second year. Fascinated by the way that changes in legislation can actually influence influence the economy at the top level and actually individual people's behaviour kind of right down at the bottom level, and it changes all the time. But I decided that I didn't want to do. I didn't like it either, the practice of law, and I wanted to do HR work. I wanted to be the one who's actually doing the interviewing and the one who's in the disciplinary hearings. So it was sort of the law inspired my career in HR, which I did for quite a number of years. And as I found my work through HR, again, like Carys, I found myself spending a lot of time advising on the law, culminating in advising on a TUPE transfer of several hundred roles from the UK to India in 2006-07, when the rules had only just changed. We didn't have any case law, anything. And I remember sitting there with a couple of partners from a large national law firm, not the one I'm at now, thinking, oh, I wish I was doing that, as they were advising me on it. Oh, I could have done that. What if I, could do that? And went back to law school and decided to become a lawyer. But I was always going to be an employment lawyer. There was never any doubt in my mind. It was my first love. I'd worked in it all the way through my career, and coming from that background into HR, into employment law, has been it's actually been really useful. It's I think it's quite unique, actually. I know a lot of people who have gone from employment law to HR, but not necessarily the other way around. And to be able to talk somebody through how to actually handle a disciplinary meeting when you've actually done it yourself, I think is quite unique. And, especially with large scale restructuring, that's a difficult one to handle. And having stood there in front of people and explained to them that they're going to be made redundant after somebody from India is going to come and do their job, is I wouldn't say it's a pleasant thing to do, but if you have done it, I think it makes you more credible and actually understand better what it is like for people who are our clients.
Thank you, Helen. That's really interesting. I'm keen to also now, I guess, focus on a bit about the day-to-day and what the team setup looks like at your respective firms. I'm going to come to you first, Elizabeth. Could you tell me a bit about the team setup at your firm and what that looks like when you're working on an employment matter? Would you say that it kind of the way that a team is set up would vary, looking at contentious matters versus non-contentious?
A good question. So actually at Jones Day, we have a very small employment team. It's one partner and three associates. So often the associates get a lot of hands-on experience, which I've really enjoyed. I would say generally on disputes and employment tribunal matters, it will be two associates and a partner, or one associate and a partner, depending on how busy the case is. And of course, we have trainee assistants as well on all of these matters. And then I would say on kind of the M&A deal work and advisory work, it would typically just be one associate working on that or the partner, depending on the issues at hand. So yeah, that's probably very different to say a Lewis Silkin employment team. But as you'll see, different firms have very different kind of setups, and the way that their teams are kind of created can be very varied.
Thanks so much. And Carys, as work comes through, would you say that your day-to-day is quite steady, or do you sort of experience lots of peaks and troughs in work?
I think there's definitely lots of peaks and troughs as you go through. We're often the first people that a HR, as Helen might would say, pick up the phone with a question, and so you never really know what's going to come on your desk each day. And that's part of the thing I love. You're often there as in ear to listen to or to provide advice. But I think I think the other lawyers on the call as well might be able to say employment law is such a busy area right now. There's an awful lot going on. I think we're going to touch on it later, the number of changes that are coming through and the number of litigation that's coming through as well. So employment tribunal claims are increasing. It's such a busy flow. I did a bit of research before this call, and I think it's up 23%. So we're a quarter higher this year than we were last year in claims. So it's great for junior ends as well. You can get involved very early on. You get to see cases running through, and it's really good experience from that litigious side. But I think day to day, it's very difficult to say exactly what you're going to do because it's often what clients need you to do and how you can help support them that day.
Thanks, that's really interesting. And yeah, 23%, that's a really big uptick in work. So that's really interesting to hear as well. Speaking about the work itself and approaching a matter, Helen, how would you kind of approach understanding what a client is trying to achieve in a matter?
Simplest way is to ask them. So one of my very first questions after getting a view from the client about what the issue is what outcome are you looking to achieve, or where do you want to get to with this, and understanding what it is that they want to get. Sometimes it's absolutely obvious. If you're working on a corporate M&A transaction, client wants to buy the business or sell the business, depending on what they're doing, but client wants to buy the business and wants to understand the risk profile. So it's self-evident, but sometimes it takes a little bit of time to tease out from the client what exactly it is that they want, because with the advisory work, they'll ring up, they've got a problem, they'll tell you everything about, and then they did this and they did this and they did this and they did this, or there'll be some timeline that's probably gone on for some time, and I'll get an understanding of the issue, probably paraphrase it back to them and say, is that what it is? And then what outcome are you looking for? Where are you trying to get to? And sometimes they don't really know. They want you to help guide them, but a lot of the time they pretty much know what it is that they want. They're just not quite sure how to put it.
Great, thank you. You said we've kind of touched on it briefly, but as quite a lot of your work is quite preventative, Helen, how would you say you kind of categorize that as opposed to the work that comes with more maybe reactive work?
I think it's an interesting one because all work is prevented. We're all trying to prevent something. So whether it's trying to prevent further litigation, whether it's trying to prevent increased costs, whether it's contentious, non-contentious, we're trying to prevent or reduce risk to our client, and prevent things from dragging on and becoming unduly costly. I think when you do non-contentious work, I suppose it's putting in place all the ingredients that need to be there. So in a contract of employment, making sure that the drafting is really precisely done and correct, so it's absolutely clear. So you're not entering into litigation over, well, actually the notice period should be 2 months, not 1 week, because the probationary period does or doesn't apply, which is actually an example of a recent thing I've been dealing with. So it's making sure that those things are right in the first place. We talk a lot about getting it right from the start, and making sure that it's right from the start. So in terms of how much of my work is preventative, I'd say probably all of it, but some of it also is reactive, because people pick up the phone to me when something's gone wrong and I have to react to that. And that's when you come in with, well, I try my best to keep it out of the tribunal, and if I fail, then I pass it on to a colleague.
Great, thanks for sharing. And I guess on that other more contentious side, Elizabeth, could you share a bit how I guess the day-to-day might differ working on a more contentious side?
Sure. So I just further to what Helen has just said, I would say reactive employment work revolves more around, say, live disputes and more urgent issues such as managing exits. Carys touched upon this. The injunction high court litigation work can be incredibly urgent. So I think in that respects, it's kind of handling issues as and when they arise quite quickly. And so you can kind of see your day derailed a bit if that comes in the morning, for instance, versus the more preventative work that Helen was talking about that is structured really around reducing risk before it crystallizes. So as she said, drafting employment policies, contracts robustly, providing trainings to managers, things like that. So I would say that those are the key differences.
Thank you. And then when you're in a situation where you're working on a tribunal or in a litigation, what factors do you need to consider?
I'd say you would look at a broad range of factors. You look at the broader kind of commercial and operational landscape, as well as the strength of the claim. Potential costs is obviously a huge one. The remedies that the client can get, and ultimately it's the client's appetite, right, for settlement versus litigation. Does the client want to settle, or do they want to defend the claim? We at JD we act for employers. And other factors include reputational risk. Obviously, litigation is conducted in a public forum versus settlement discussions. So it really just depends on what the client is looking for and what outcome they want to achieve.
Great, thanks so much. And finally, Elizabeth, I'm also keen to know, I guess, what comes into play when, I guess, work is more international. Would you say that a lot of your work is international when there's a cross-border element?
I would say definitely. So for those that don't know, Jones Day is an American law firm, and we have around 40 offices around the world. So we work a lot with our colleagues in other offices, particularly on advisory and corporate work. So for example, in an M&A context, we work frequently with our overseas colleagues, liaising with them on due diligence reports, due diligence questions, marking up sale and purchase agreements. We often liaise with, say, our American labour and employment counterparts or our European L&E counterparts. And then in the advisory space, we sometimes receive employment queries from clients that have operations in many different countries and jurisdictions. So they may funnel a question to the London employment team and say, can we have advice on what the position is in these 10 countries, for instance? And then it would be kind of our job to reach out to the lawyers that work in the Madrid office or the New York office, the Singapore office, to kind of get their views. And then if you received the original client query, then you would collate that response and then send it to the client. So depending on the client request, we really do quite a lot of international work, which is definitely something that I really enjoy about Jones Day and the job.
Thanks so much. That's really interesting to hear. So now we've kind of covered a bit about the work and the different aspects of that. I'm keen to turn to focus on the elements of the role that lawyers get involved with outside of just the general practice of law, whether that be pro bono or business development. I'm going to start with you, Carys. You're involved in organisations like the Pankhurst Trust and Manchester Women's Aid. How does this work influence your perspective as an employment lawyer, and why is pro bono so important in this field?
So I volunteer at the Pankhurst Trust and Manchester Women's Aid primarily because I have a personal interest in progressing women's rights and supporting women, particularly in my community. I think there's a huge value in giving your time back to support your local community and to help out where you can. It also widens your experience. It widens different perspectives and understanding. And while I don't necessarily provide legal advice in this avenue, it's something I think is really important because it does give you that exposure and experience to people who do need support, and you can point them in the right avenues, or you can just be there as an ear to listen to and to offer your support and your time. It does link into my work internally that I do. My firm does have a gender equality network, which we're really strong on. That's not just for women, it's for men as well. The thing I think my firm's most proud of within the network is that we have equal paternity leave, equal parental leave, which is something that we've fought for quite a long time. So that's for both genders in the equality network. And I attend events in Manchester, such as the Female Lawyers Breakfast Network. So it's just areas like this, if you do have a passion or an interest, it doesn't have to completely link to your legal career. It doesn't have to link to your profession, but there's lots of ways that it can. And I always think if you are genuinely passionate and interested about something, that comes across and you enjoy a lot more about what you do. So as I mentioned, mine is a lot around gender equality that I work on, but you'll have the up in Manchester, I know there's the Black Solicitors Network, there's the LGBTQ plus Solicitors Network. There's a lot of different areas which, if you can combine something you're passionate in and something you want to promote and enhance, you can always tie that back to your career and your profession. My firm takes on 30 responsible business hours that can count towards chargeable targets. So it's actively promoted and encouraged within the firm that you should be going out and doing pro bono work, and you should be going out and acting responsibly and supporting other areas of the community. So I think that's incredibly important. Pro bono is amazing. I advise anybody on this call, if you haven't done pro bono work before, to look at reaching out to university law centres or other pro bono clinics. It's a brilliant way for you to get exposure to real cases. It gets you exposure to other lawyers who will supervise and advise you, and you get to meet clients that way. And on a personal point, I've never met a lawyer who, if you said, can I have 10 minutes just to ask you a question? Or can I ask about what you did today? They've never said no. I think anybody, if you take that proactive approach and you're genuinely interested in supporting, nobody's ever stopped me, and I'd be surprised if they did, answering your questions or being that support if you needed it. So I think pro bono is really important. It rounds you out, and it's a great way if getting vacation schemes or work experience, I know, can be incredibly difficult. So it's a great way to get real life exposure while also supporting those who can't necessarily afford legal advice themselves.
Thank you so much. That's really interesting, and I definitely agree. Like pro bono is a great way to help the community, but also to help build your skills as well. And on Law Careers.net, we actually have a page of pro bono initiatives, which details a bunch of different initiatives that students can get involved in, like citizens advice, that kind of thing. So I definitely recommend students take a look at that. Turning to focus on business development, Elizabeth, could you tell me how employment lawyers typically generate new business?
Sure. So I would actually say that employment lawyers try to generate new business in a very similar way to how other lawyers and other specialisms would try to generate new business. So firstly, it's expanding existing relationships with clients that your respective firms already have, and just through general business development opportunities, whether that be through networking, speaking at panel events, other business development events such as women's events, certain diversity networking events. I think all of these things can help generate new business. Just trying to have regular contact with clients, going for coffees, things like that, I think what applies in employment law can apply across different practice areas. And I think it probably goes without saying that generating new business, an important part of it is just providing good client service and doing the work that you have for your existing clients well, because then you'll just get a reputation as being a good and reliable law firm. I think that's probably a good way to go about it.
Great, thanks so much. I think I've heard a lawyer say before that the best way to generate new business is just to perform your existing business well, which I think is a great point. Building that reputation is key to business development. So thanks so much, Elizabeth. And then I guess thinking about how employment law interacts with other practice areas, Helen, would you say that kind of plays a role in business development in terms of passing over clients from practice area to practice area or that kind of thing?
Hugely. Actually, in fact, I think probably 100% of my workload comes from other departments, either our commercial department who might be working on an outsourcing contract and need some input from employment on transfers of undertakings. My M&A work obviously comes from corporate. My exec exits are usually from corporate clients. Maybe I've worked on the transaction in the first place where it's been a management buyout and private equity, and then they've fallen out with the CEO and want to exit them. So that's where I'm getting my work from. One of the things we say in our team is, well, do any of your clients employ people? Because if they do, they could be our clients. So, the whole range of other teams that we've got here, commercial, corporate, real estate, house building, any of them, and all of them are potential business development areas for us. And it's so much easier to get that introduction to a client that's already working with Gateley than it is to try and go out and get brand new clients that are unknown to the firm.
Great, thanks so much. And just a kind of question that's just popped into my head now off the back of that is, like, you've mentioned going out and finding new clients that are new to Gateley. To any of our panelists here, how would you say you kind of approaching your work, I guess, getting the name out, spreading the word about your firm and the work you do to perhaps clients that don't work with your firm yet? I don't know if anyone has any thoughts on that.
It is, I think, about the profile raising. So going on webinars, going to conferences, delivering talks and delivering training. So we do regular open training events that anybody can book on, that we publicise, just pure marketing, posting things on LinkedIn, and building those relationships with existing clients and getting work through referral. Those are the ways that all departments really go about getting new clients, but that's particularly an area, I think, with employment law, because there's so much change. You can constantly be commenting on a new case that's come out. Of course, there's the Employment Rights Bill, and delivering training to managers, and there'll always, I think, be a demand for that.
Great, thanks so much. I'm going to come on to the Employment Rights Bill now, as we're going to discuss some hot topics and trends that are impacting the sector. Just before I do, just a note to all of our attendees to remember to put your questions in the Q&A tool, and just because we'll be coming to answer those very shortly. So it'd be great to hear if you have any questions for our panelists today. So touching on the Employment Rights Bill, which I think we couldn't have this masterclass without talking about, Carys, this has brought so many changes, and these have been discussed in the news quite a lot, like the unfair dismissal protection, limits on 0-hour contracts, so many others. How does this affect employers and employees, and I guess the work you do?
Yeah, so anybody who does have an interest in employment law can't have missed the fact that the Employment Rights Bill is currently being discussed in Parliament. It's on the news all the time. So you mentioned there unfair dismissal protections. Up until only a few weeks ago, we were still using the phrase day one rights. But if anybody's seen the ping pong between House of Lords and House of Commons, day one right isn't a thing anymore necessarily, but we're looking at 6-month protection, which is coming down from the 2 years. So previously, to bring an unfair dismissal claim, you generally had to have 2 years of service. So you had to have worked for your employer for 2 years before you could bring that claim. And the new bill proposes to bring that time frame down to 6 months. So this has an impact on probation periods, how that's going to be reviewed. It arguably could have an impact on recruitment. Will there be more stringent tests before people come in? Will there be more rounds of recruitment to ensure that you're getting the right people in if they can start to claim unfair dismissal protections earlier on? They've also commented on lifting the compensation cap. So currently for unfair dismissal, you can only claim for generally 1 year of service, or I believe the figure now is around 118,000. That's being lifted. So you may have some senior executive out there. Helen might not like this necessarily or like it, depending on which one you advise. There might be some senior execs out there that can have a huge impact on. It may encourage them to bring more claims down the line if there might be a greater compensation award. So these are all things that companies need to think about from the very beginning of recruiting all the way to the very end of possibly exiting. These bills does impose changes. You mentioned 0 hours. There's looking at offering guaranteed hours. So if you work consistently over a certain proportionate period, you can guarantee that you have those hours and your employer can't restrict that. There's restrictions on fire and rehire. That's often hits the news when it happens. P&O Cruises, very well known a few years ago, decided to fire all their members of staff and rehire. And there's going to be restrictions around what you can do there. There's a number of other, I'm not going to go into everything. This could be a whole talk in itself, but I definitely recommend if people are interested, lots of news articles and blogs right now. There's lots of discussions going on. My own firm has a whole web page that's dedicated to posting articles specifically to labour reforms and the workers' rights bill or the employment rights bill that's coming through, because it's a constantly updating almost every week. So I do recommend anybody who does have an interest in employment law, there's lots of content you can find, and there's going to be a lot of work coming through from it. And anyone applying for jobs or vacation schemes, I'd very strongly suspect you have a question on it. So I'd have a bit of a read to try and understand what's going on.
Great, thanks so much. And that's really great advice in terms of having a look at the firm's thought leadership as well. I think that's like another great way to build commercial awareness of topics, and also what work that firms are working on, when you might be applying. Helen, aside from the Employment Rights Bill, what other developments or trends should employers or lawyers be paying attention to?
I think there's one that is coming in to legislation quite soon, which is partly there's some aspects of it in the Employment Rights Bill, but actually quite a bit of it is outside of the Employment Rights Bill, and that's around industrial relations and collective employment matters and trade union work. So this government is very keen on giving employees a collective voice and encouraging people to become members and participate in unions. So there's a lot of change, legislation being repealed so that there's legislation that makes it more difficult to go on strike, that's being repealed, and other legislations being put in place that will make it more mandatory for employers to allow trade union representatives on site to talk to people about becoming union members. So I think an area where possibly over the last, say, even 20 years has not has sort of fallen back against individual employment rights. I think we're going to see an awful lot more around collective employment rights and trade unions. And then the other area which I think we need to look out for is around technology. For ourselves as lawyers, everybody will have heard talk about AI and what's AI going to do to our jobs, but actually from talking to HR people in a range of businesses, actually AI is a massive challenge for them. Is it taking jobs? Is it reducing the workforce? How do we implement it? How do we set the guardrails? Because a phrase that's used sometimes is we're building the plane while we're flying it, and people are using AI, but I don't know about you, but is there a policy that says, well, you can use this, you can't use that, you can't disclose confidential information? And those are all the challenges that are facing employers. So around job design, about the quality and quantity of work, about organisation design, what kind of people do we need? So I think those are big challenges for employers and also for us as professionals.
Great, thank you. That's really interesting. Thinking about as well other aspects that as well as technology and everything we've discussed so far that's impacting work. I've seen a question coming through now, which I think is quite interesting, which is how has remote and hybrid work changed employment law disputes? Does anyone have any thoughts on that?
And there's a fair few disputes about home working, remote working, and hybrid working, and the so-called RTO mandate, so the return to office mandate. We do get. I've certainly had clients who want advice where say head office or the owners of the business want everybody back in the office full time, and nobody wants to do that, or certainly doesn't want to be back full time, and then there are disputes over it. And also flexible working requests. So people have got quite used to working full time at home, who simply might have moved away somewhere so they can work remotely, just simply do not want to be back in the office. So there's a lot of flexible working requests and lots of challenges and law around that. So I think from the employment lawyer's point of view purely, it has led to a lot more dispute, I think, and friction and tension, where the employer wants one thing and the employees maybe want something else.
Interesting, thank you. And Carys, do you have something to add on that there?
Well, I think Helen touched upon it. I was going to mention on that flexible working request. There's been reforms where now 2 can be submitted in a year, and the onus has been pushed back to the employer to say why it's not reasonable. So it used to be the employer had to put forward almost a business case of why they wanted it, how they'll make it work. And as with quite a few of these reforms that are being proposed, the onus has changed. So as I advise employers predominantly, it's now advising our clients on what to do when one comes in, what's reasonable, how to justify that. And so it's that advisory point has changed from what it used to be, with the increase of flexible working requests coming through.
Great, thanks so much. I'm going to turn to a few more of the questions from the audience. I've got one question specifically about Lewis Silkin, Carys, which is asking what tasks trainees might be expected to carry out in an employment seat.
Yes, so Lewis Silkin I think it is the largest employment law firm in terms of employee numbers. So there's an awful lot of us and there's an awful lot of employment law to do. So a trainee, one trainee to another, we have a lot of them in employment, doesn't necessarily do the same thing. One thing that they can get involved in that I do a lot of, so I do a lot of investigations, as mentioned, so being note takers in that, helping draft questions, helping pull together evidence. Personally, I love it. I'm just a bit nosy, so when one comes in, I absolutely love an investigation. And I think it's really great from a trainee perspective that you get to see the client, see the people you're speaking to. A lot of it's around judgment. So it's building those skills of, well, what did you think and why did you think that? And what evidence can we pull on to reach that conclusion? I think they're very good skills to pull forward, and they're really interesting. Obviously, you still have your settlement agreements, you'll have your contracts, you'll have your advisory work, and tribunals, as I mentioned, they're just growing day by day, it seems, with the backlog in the tribunal system right now. So trainees will definitely be involved in, at the early stage, getting all the evidence together, drafting witness statements, preparing documents for counsel and for the tribunal. So I don't think there's very much that a trainee couldn't be involved in at some level. At Lewis Silkin, they can be involved in all the meetings that take place, and because there's such a range of areas, as mentioned at the beginning, employment law, it's quite a varied seat.
Perfect, thanks so much. And another question I've got that's come through, which perhaps might be quite a good one for you, Elizabeth, but everyone feel free to talk to it, is what are some common mistakes that employees make when a dispute arises? So kind of on the dispute side.
That's a good question. I think sometimes we see when an employee files an ET1 claim, often their claims can be out of time. So I think just getting the right advice in terms of whether they're within the limitation period to bring a claim is one that we do see quite a lot. I'm not sure if other panelists have any other thoughts to add on that.
I think another thing is employees make the mistake of identifying legal rights and if they're disgruntled, well, I've got all these legal rights and I'm unhappy and I want to bring a claim, but don't necessarily match their own, what has actually happened or not happened to them, to the particular legal right that they're talking about, which can make it really difficult for the employer to try to resolve the issue when somebody's telling you that section X of such and such a regulation says this. Well, yes, we know that. What is it that you're saying about that? And that is becoming increasingly common. I don't know if the others have seen this, but increasingly common with ChatGPT, where employers are on the receiving end of 33 pages of the law says, generated by ChatGPT, which gives people confidence that they've got a case, because it makes disputes more difficult then to resolve, and actually just gets really frustrating for everybody. But I think those are the mistakes where people get buoyed up with the idea that they're somehow being done wrong, and there's legal rights, but not connecting it, and not really understanding the limits on those rights, or having a realistic expectation of what they might actually achieve as well. 33 pages of ChatGPT telling you the law in some jurisdiction, not necessarily your own, followed up with, and I think I've got a claim that's worth at least £150,000, which, spoiler alert, highly unlikely.
I see Carys nodding there. Did you have anything to add about how AI has kind of impacted these sorts of things?
Oh, it's fun and games right now. Yes, as Helen mentioned, there's an awful lot more in the employment tribunal, particularly of litigants in person. So I fully respect anybody who wants to go and present their case, but we are seeing an awful lot of ChatGPT responses coming through, and it is sometimes quite difficult to pinpoint exactly what somebody's case is. There's a very big difference between you not liking your manager and your manager harassing or discriminating against you. But I'm not sure that those terms, I think they're used quite broadly off, and I'm not sure that litigants in person necessarily understand that. And so that's where you can sometimes have a difficulty as an employment lawyer, where someone might have made a mean comment, or you might just not get on, but that doesn't necessarily mean you have a claim to bring. And that can be difficult to explain sometimes.
Thank you, Carys. And I've got another question here, which is quite similar to something that I was going to ask, which is in terms of resources, if you're a student interested in employment law, how can you stay up to date with changes? Does anyone have any resources that they'd recommend?
Sounds a bit odd, I think, coming from somebody else, but actually Lewis Silkin's, it's an excellent resource. It's a really good resource. Yeah, I think all employment lawyers go, well, what did Lewis Silkin say about it? And I've heard Colin Leckie speak, who's quite an expert on the Employment Rights Bill. So if you want to know about the Employment Rights Bill, I would go and have a look at what Lewis Silkin is saying. But actually, just pure old-fashioned Google it. Obviously check your sources, but keeping up to date with news feeds does feature in the news. You'll see it on the BBC, you'll see it in the press. set up alerts, and just see what's going on. There's a lot going on with it at the moment. Some of it's quite techy and geeky about the ping pong and who's considering what amendment, but just kind of keeping up to date in it and finding sources of information and then tagging those for alerts. That's what I would do.
Fantastic, thank you. Great. So before we round up the masterclass, and I hand back to Amina, I'd just like to finish up with a quick piece of advice for each of you for our attendees of the panel today who are interested in perhaps going into employment law. What advice would you give to an aspiring employment lawyer, starting with you, Carys?
Yeah, so my main advice would be small and often. I think it can be quite difficult sometimes to feel like you can access the field, access the industry, particularly if you don't know anybody. So I think trying to go to events and speak to people, and LinkedIn is your best friend. If you don't have it already, try and use it. That's how you build your own network. And it's very difficult as a junior to feel like that you can have an influence, but those small and often events, and they're what, when somebody asks you in an interview, why do you want to do this? It's pulling back on that experience and saying, well, I spoke to so-and-so, or I heard this at this event. And it's really trying to round out why you actually have a genuine interest. So if you don't have any connections, I don't think that's the end of the world. It's just trying to keep yourself up to date and trying to attend what you can and have access where you can. There's lots of free networks and free events and groups that you can join. So have a bit of a search and a research, or go on LinkedIn and reach out to somebody and say, I'm struggling, I live in this place and I'm struggling, can you point me in the right direction? And I'm sure, again, not speak for all lawyers, but everyone I've ever met, I'm sure they would reach out and help you.
Fantastic, thank you. And Elizabeth, any final advice?
Yeah, I think just people looking to break into law more generally, not necessarily just employment law. I think just resilience, and because it's a hard field to get into, but if you keep applying, keep stay on top of the news, as Cara said, message people on LinkedIn. I do believe that something will eventually work out, and that you will find a job in the space that you want to. And I think another advice point would be to just build commercial awareness. I know it's the dreaded buzzword that all students hear about, but really just staying on top of the news, thinking about how what's going on in the world can impact a law firm, how it can impact the business of a law firm. I think if you think about those questions, it can come across quite well in interviews.
Fantastic. And finally, Helen?
Not got much to add to that. I think that's absolutely right. Don't be afraid to use LinkedIn. I'm very happy for anybody who's attending to send me an invitation on LinkedIn. I don't have my alerts turned on, so it might take me a while to get around to it, but I will always accept a request, and I'll always reply to messages. The only other thing that I've got to add to that is, if you're interested in employment law, you can actually show up to an employment tribunal. They're all public hearings. You can ring up the tribunal office in the evening, try after 4 o'clock, and say, what hearings have you got on, and see if there's any. The particularly good ones to go and sit in on would be a one-day unfair dismissal hearing, if there are any, and you can just say, you can show up and introduce yourself to the clerk, and they'll show you in, and you can sit in and see what actually goes on in a tribunal.
Amazing. Thank you. That's a great piece of advice to finish up with. I'm going to hand back to Amina now to finish up the masterclass.
Thanks, Ellie. So I'm just going to end with going to ask you a final poll for your key takeaways. So I'll put the question up now. And I'll just give you a bit of time to get your answers in. I'll give you all just a few more seconds. Great. So these are the results. It's great to see what you've taken from this session, from knowing more about the work of what an employment law solicitor entails, to sort of like understanding some of the key issues facing the practice area at the moment.